Quickie. If you want to know how absurd the concept of obscenity is, just look at the Supreme Court decision Jacobellis v. Ohio. Theater manager Nico Jacobellis was charged in 1963 with possessing and exhibiting an obscene film when he screened the French film Les Amants, and his conviction was upheld by both the Ohio Court of Appeals and the Supreme Court of Ohio. The Supreme Court overturned it 6-3, saying the film was protected speech. But there was no majority opinion since no more than 2 justices could agree as to why. William Brennan viewed the film and just said it wasn't obscene, but didn't even try to explain why. Arthur Goldberg, concurring with Brennan, said, "I wish merely to add to my brother Brennan's description that the love scene deemed objectionable is so fragmentary and fleeting that only a censor's alert would make an audience conscious that something questionable is being portrayed." Byron White concurred, but didn't write any opinion at all. Hugo Black and William O. Douglas took a good, hard-line First Amendment stance. If, despite the Constitution, this nation is to embark on the dangerous road of censorship, this court is about the most inappropriate Supreme Board of Censors that could be found. The conviction of appellant or anyone else for exhibiting a motion picture abridges freedom of the press as safeguarded by the First Amendment. Good for them. And that brings us to Potter Stewart, who really gave us the only real standard for obscenity there's ever been. I imply no criticism of the court, which in those cases was faced with the task of trying to define what may be indefinable. I shall not today attempt further to define the kinds of material I understand to be embraced within that shorthand description, and perhaps I could never succeed in intelligibly doing so. But I know it when I see it, and the motion picture involved in this case is not that. As for the dissents, Earl Warren and Tom Clark said, "Neither courts nor legislatures have been able to evolve a truly satisfactory definition of obscenity, and yet they still upheld the conviction. Basically, since the lower courts had already declared it obscene, the Supreme Court couldn't second-guess them. But then, what's the point of the Supreme Court?" Cowards. That leaves John Harlan's dissent. He wrote, "As to the states, I would make the federal test one of rationality. I would not prohibit them from banning any material which, taken as a whole, has been reasonably found in state judicial proceedings to treat with sex in a fundamentally offensive manner, under rationally established criteria for judging such material." But then, again, what's the point of the Supreme Court? Or even the Constitution? Unfortunately, since then, the Supreme Court hasn't done any better at shedding light on the obscenity issue. If only we had more justices like Black and Douglas. The First Amendment permits no censorship of any kind. Maybe someday.